we have the adversarial system, and before the adjudicating tribunal, it is always that one party will lose the case and another party will win the case. So the party that will lose the case is known as aggrieved party, and for that, whether that party have right to make appeal, so to get rectify the judgment or not, and where it has to file the the appeal. So the party has to file, aggrieved party has to file the appeal before the appellate tribunal. And today we will discuss the different aspects of the appellate tribunal. So I would try to complete it, this whole procedure in this particular lecture, so that in next lecture we can start new thing. And you also must cooperate. Any question you have, try to ask it at the end of the lecture. Okay. So the appellate tribunal, and I have framed 10 questions with respect to this whole proceeding. The first one is whether the party, after getting the decision of the adjudicating officer, has the right to appeal or not. And for that, the answer lies in the section 57 subsection 1. See, this whole part, whole chapter 10 of the IT Act is related to the the appellate tribunal. When this act was enacted in 2000 in information technology, it was envisaged by the legislature to have a forum, cyber appellate tribunal, and to decide that forum the appeal from the adjudicating officer or the controller also, that we discuss under the public key infrastructure controller, controller of the certifying authority, CCA. So if there is any fault with respect to the certifying authority, like fraudulently publishing the electronic signature, etc., in that case the investigating power have the certifying authority. I think you remember all those things. So with respect to that, so the first is right to make appeal, whether the aggrieved party have the right to make appeal or not. And for that we have the section 57.1. Section 57.1 says that save as in the subsection 2, any person aggrieved by the order made by the controller or the adjudicating officer under this act may prefer an appeal to the appellate tribunal having the jurisdiction in the matter. So from this it is clear that yes, the party against whose there is the judgment, and you can say in whose favor the order of the adjudicating officer was not, can make the appeal. And then the second question also answered here, that where he has to make the appeal. So it the party, aggrieved party, has to make before the appellate tribunal having the jurisdiction. Now its subsection 1 of the section 57 start with save as provided. See, we read the compounding of the contravention under adjudicating officer also, and this compounding of the contravention here also in this chapter 10 also you will find the provision. So the compounding of the contraventions is like the compounding of the offenses under the criminal procedure code. Suppose A has unauthorizedly accessed the computer system of B and then deleted the data. So B is the party who is aggrieved party, A is the wrongdoer, and when then B filed the complaint before the adjudicating officer, and he did wrong, so he admit it's wrong and want to compromise at this stage, that whatever loss you suffered, I am ready to give you. So that is the compromise. So that is the compounding. You can say compromise or the compounding of the contravention. So suppose there is a compromise, the compounding, the order in which the consent of both the parties there. So in that case no party is the aggrieved party. And subsection 2 of the section 57 is talking about that if the order of the adjudicating officer is of the consent of the party. In that case, the appeal is not allowed, because that is not required. Similar provision you will find in the civil procedure code also, when there is the compromise decree, in the consent decree or in the compromise decree. In that decree, because there no party is aggrieved. Okay, so section 57 and section 57 clause 2 and section 57 clause 1 gives the answer to right to make appeal. Who has the right to make the appeal? The aggrieved party. What aggrieved? The party against whom there is the decision of the controller or the adjudicating officer, because we are concerned here about the adjudicating officer, so by emphasis is on the adjudicating officer, but it is also with respect to the controller. So whatever the investigation and all those things we have discussed, and after investigation, the controller of the certifying authority even can suspend the license, can revoke the license of the certifying authority. So certifying authority appeal में appellate tribunal के पास जाएंगे. Okay, the second question is that where to make the appeal, and section 57 subsection 1 gives answer that appeal to make to the appellate tribunal. So what is this appellate tribunal? For that we have to visit now to the section 48. See, in the chapter the appellate tribunal, there also you will find that it was amended. Then the name of appellate tribunal, it was also amended. There are many provisions you will find that are deleted. See, when this act was envisaged, it was envisaged that there would be an appellate tribunal and the name would be the cyber appellate tribunal. So the provision with respect to the composition of the tribunal, their eligibility, condition and even rules were framed. Then the government found that it is not possible to constitute the tribunal because they have not found the suitable persons. So it was not even make functional after the 17 years. And so in 2017, the parliament has amended many provisions and making that already working tribunal under the TRI Act. So the Telecom Dispute Settlement and the Appellate Tribunal, that in the brief is known as, or in acronym known as the TDSAT, constituted under section 14 of the TRI Act 1997, will also hear the appeal from the these adjudicating officer by virtue of section 57 subsection 1. Similar thing you will find under the Competition Act also. There also under the Competition Act, tribunal was constituted, but finally that tribunal was not made functional, and the power is given to National Company Law Appellate Tribunal to hear the appeals from the Competition Commission also. So similar thing that the TDSAT is the appellate tribunal, and so the names has been changed from the cyber appellate tribunal to the appellate tribunal. With that, many provisions has been deleted because now there is no need about the composition, whatever the TDSAT, that compositions and other matters related to it, like the salary allowance, term, condition, power, etc. So many section you will find under this chapter 10 that are not functional, that has been deleted now by the Amendment Act of the 2017. When we read section 2000 section 48, it says that the Telecom Dispute Settlement and Appellate Tribunal established under section 14 of the Telecom Regulatory Authority of India shall, on and from the commencement of part 14 of the chapter 6 of Finance Act, be the appellate tribunal for purpose of this act, and said appellate tribunal shall exercise the power, jurisdiction and authority conferred on it under the act. And so what the section 57(1) is saying, that the appellate tribunal that have the jurisdiction to that the appeal will prefer. Here under the section 48, the TDSAT is that tribunal that have the jurisdiction and the power, and so to the TDSAT the appeal will lies. The second thing is here that it would be the one appellate tribunal, or it will be more than one appellate tribunal having the jurisdictions different for the different area. and that the answer you get from the subsection 2 of the section 48, that the central government shall specify by notification the matter and place in relation to which appellate tribunal may exercise. So means maybe there would be more than one appellate tribunal, and that appellate tribunal have the jurisdiction to that particular areas, only 2 to 3 state, whatever the jurisdiction the central government wants to specify, that is also possible. Now the third question is, or the third thing that we have to discuss is that yes, appeal will file, but in how many days one has to file the appeal? Because for the normal, if we talk about the civil proceeding, there is the civil procedure code along with the law of the limitation that prescribe the time in which the suit has to file, or the appeal has to file, or the application has to moved, etc. So what is the time period? Because here the civil procedure code is not apply, limitation act also not apply, because that is applicable for the judicial proceeding, etc. And so here is the section 57 subsection 3. Now we again come back to the section 57 from the section 47 that talk about the limitation period. Section 57 saying, 57 subsection 2 subsection 3 saying that every appeal under subsection 1 shall be filed within the 45 days from the date on which the copy of order made by the controller or adjudicating officer is received by the person aggrieved, and it shall be from such form and the fee. Okay, I am leaving this last line. So it will be 45 days from the date on which the copy of that order of the adjudicating officer that person received. Then there are some other question that comes. The one is about that suppose a person has not able to file within the 45 days because he was not sound for some time, कुछ देर के पागल हो गया कुछ समय के लिए, or maybe he was very ill, or maybe there are some other reasons also. So in the law of the limitation, if you remember, there is one provision, section 5 of law of limitation, that talk about the condonation of delay. Because it's not that always if a strict limit is prescribed and all person will be in the same position. Maybe there is something wrong with that person, and for that excuse is needed, otherwise he will lose his right. And so the condonation of the delay, that in the civil cases we talk about the section 5 of the limitation act. Here with the condonation there is the proviso attached to this section 57 subsection 3, and proviso says that provided that appellate tribunal may entertain an appeal after the expiry of the said period of 45 days if it is satisfied that there is the sufficient cause for not filing. So what is the sufficient cause for not filing? And for that what is the rules that has been propounded by the courts under the limitation act, all those rules, because both are in the same on the line, and so those rules will also be applicable. Like it does not mean that every day's account has to be given if the person is the ill or some other things, that the appellate tribunal feel it's that yes, there is the sufficient ground, so he has to think judiciously. The second thing is about that suppose the 45 days is decided, suppose on the 45th days there is the holiday. Okay, one has to file the appeal within the 45 days from the date on which the order was received by the person, and on the 45th day there is the holiday. So under the law of the limitation there are some rules that if it is a holiday last day, then to the next working day, suppose there are the 4 or 5 holiday in the consequence and the next working day, and so there are many other things that need to be answered. And so the legislature says that for that the applicability for the calculating this time of the 45 days of the appeal, the law of limitation will be applied. We have to read section 57 subsection 3 with section 60. Is it visible to you guys?
Yes, sir.
Section 60 says that the provisions of the limitation act 1963 shall as far as may be apply to an appeal made to the appellate tribunal. So that we have to read with it. Then the fourth question is about the form. In what form one has to file the appeal, because it is not the like the civil court where already there is the that how the appeal has to be filed, etc. In the civil procedure code there is the whole procedure. So here in how, like for the adjudicating officer, how the complaint has to be made, a pro forma has been given on the plain paper. One has to write those detail of the the complainant, respondent, the date and time, etc., etc. So similarly here, what is the form and fee? And for that, this section 57 again section 57 subsection 3 is saying, and section 57 subsection 3, if you see that from here, that every appeal under subsection 1 shall be filed within 45 days from the date and on which the copy of the order made by the controller or adjudicating officer is received by the person aggrieved, and it shall be in such form and be accompanied by such as may be prescribed. So that means the act is silent, but it giving the reference that the government through the rules can prescribe. And for that you have to read the rules, the Cyber Regulation Appellate Tribunal Procedure Rule 2000. There under those rules, or you simply can find out these rules in your Bare Act relating to the Appellate Tribunal Procedure Rule 2000. Here the rule number 6 talking about the application, and you will also find the content of the application under the rule number 6. So rule 6 and 7, and then the pro forma, there you can find out that how the appeal has to be filed and what fee has to be paid. 2000 fee has to be paid. Then the fifth one is the time period to decide the appeal, because the very purpose of creating these forum, these separate forum for the dispute resolution, other than the court, is to reduce the time so that quickly they can decide. And that's why the presiding officer is not a judge, not the civil procedure code will apply, only with the purpose of reducing the time. And so is there any time framework has been set within which the case has to be decided or not? And for that, the time in which one the appellate tribunal has to decide, for that section 57 subsection 6. Section 57 subsection 6 is saying that the main guiding force is expeditiously as possible. That means court has to decide as soon as possible. Section 57(6) that the appeal filed before appellate tribunal under subsection 1 shall be dealt with it by it as expeditiously as possible. And then there is a rough time framework has been provided. It's not strictly that within it. Endeavour shall be made by it to dispose the appeal finally within the 6th month from the date of receipt of the appeal. So the within 6th month it has to be make the effort to make the appeal decided. So the 6th month is not the strict time framework, but it is the duty on the appellate tribunal to decide it, possibly to resolve the dispute within the 6th month from the date of the filing of the case. Okay. Then the 6th the question or the 6th thing that we have to discuss is that, see, section 46 subsection 1 we have read, section 57 subsection 1 read with section 48 we have read, where any contravention, if it is made under the IT Act, then the adjudicating officer will decide, or appeal will be resolved, or appeal will be entertained by the appellate tribunal. Then if you remember your CPC classes, civil procedure class, there is in the Civil Procedure Act 908, there is one section known as gateway of the civil procedure code. Okay, और that is the section 9, like the gateway of India, जहाँ से वो अंग्रेज आते थे, मुंबई में एक symbolic. Similarly, the section 9 is the thing that gives the jurisdiction to the civil court to entertain. And section 9 of the civil procedure code says that the court will have the jurisdiction. Court means the civil court will have the jurisdiction to try all the matters civil in nature, not civil cases, all the cases civil in nature. So maybe there is some question of the caste or other things involved in it, but ultimately it is related to any civil cause. Then it is the civil court will have the jurisdiction unless and until the jurisdiction is expressly barred. And so it would create the confusion that one person filed under the section 46 subsection 1 before the adjudicating officer. But what if the another person want to file before the court? He say that the court will also have the jurisdiction because expressly and impliedly it has not been barred. Section 46 को तो है लेकिन बार यहाँ पे नहीं किया हुआ है. And so that would may create the confusion. And so there must be bar on the jurisdiction that civil court will not have. And this is known as the bar of jurisdiction, and this bar of jurisdiction provision, section 61 of the information technology, this type of the provision you will find in all those statutes that envisages, that talk about any special tribunal or forum for deciding, whether it is the company law, whether it is the competition law, whether it is the IT law. जहाँ पे भी कोई नया ट्राइब्यूनल या एक नया फोरम सेटलमेंट होगा, वहाँ पे आपको एक्सप्रेसली सिविल प्रोसीजर कोड का जो सेक्शन 9 है उसको बंद करना होगा, बिकॉज दैट विल प्रोवाइड द जुरिडिक्शन टू द सिविल कोर्ट. And so that jurisdiction has to be barred, so just to avoid the confusion. Even if the expressly it has not been provided, then maybe the court will say that because section 46 subsection 1 is there, and so impliedly it means that the legislature want to give the jurisdiction with respect to IT matter only to the adjudicatory officer. But for implied jurisdiction will maybe then it would reach up to the high court or to the Supreme Court, and then they interpret and then they give that is implied. Okay, so that is very complex method. And so the legislature by way of precautions has always put this bar of jurisdiction. And this bar of jurisdiction is not only to entertain the matter, even for deciding any applications for granting the temporary injunctions also. And so the section 61, if you read, section 61 says that no court shall have the jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating officer appointed under this act or the appellate tribunal constituted under this act is empowered by or under this act, and to determine no injunction shall be granted by any court or any authority in respect of any action taken or to be taken in pursuance of any power conferred under this act. Okay, so these sections you can write on this as the bar of jurisdiction, and this type of the section you will find just to stop the confusion with respect to the section 9 of the civil procedure court. Then and so by with this bar of exclusion, the adjudicating officer and the appellate tribunal have the exclusive jurisdiction to try all the IT cases. Then the seventh question is, what about the compounding, or seventh issue is about the compounding of the contraventions, like we discussed when we discussed the adjudicating officer. Here also we will discuss again the compounding. So for the compounding of the this contravention, there is this provision section 63 that any contravention under this act may either before or after the institution of the adjudicating proceeding be compounded. So it be compounded by such officer as may be specially authorized on this behalf or by adjudicating officer, etc. This whole provision you have to read it, whatever we have already discussed. This is in tune with that provision, the compounding, because the compromise is possible, and this compromise provision is also with the purpose to reduce the time. Let the parties have to settle their things, not to dispute or not to fight over their rights ferociously in the adversarial system. So this whole these provisions are enacted with the purpose of reducing the precious time. Then the eighth thing is about the procedure. See, earlier also I have said that the civil procedure code is not applicable, because civil procedure code is applicable to the judicial proceedings, and it is not that. Section 58, because when we read section 46 subsection 5 with respect to the procedure of the adjudicating officer, there also we read that the this adjudicating officer will have the power as provided to appellate tribunal under section 58 clause 2. So here section 58 talking about the procedure that has to be followed by the the appellate tribunal, and in that procedure the first portion is that CPC will not apply, but there are certain things that are not possible without giving the power to the particular forum or the tribunal, like summoning power. Who will come if you give the summon? If the adjudicating officer or the appellate tribunal give the summon, who will appear? Because there is no binding force under the before the civil court. There is whole system binding force. So taking the evidence on the affidavit, summoning the witnesses, there are many things without which a tribunals or a particular forum cannot work in the proper manner. Then the things about the the fear of the perjury, the fear of the execution, because the in before the civil court section 193 of the IPC 228 will apply if some person will tell a lie, will falsely depose. Similarly, for the execution, order 21 of the CPC will apply only when it is the order of the civil court, and so same thing are making applicable. So all these things we will find under section 58, that talking about the procedure. Section 58 subsection 1 says that that the appellate tribunal shall not be bound by the procedure laid down by the civil procedure code. Okay, but then question comes that if the civil procedure code will not apply, so what procedure it would follow. Okay, and as an administrative law student also I think you are aware that for the quasi judicial body in the before the quasi judicial forum also, the principle of the natural justice has to be followed. What are the principles of natural justice? Three important principles of natural justice: that no one should be condemned without hearing, rule against biasness, and no one be the judge in his own cause. So that's saying that but shall be guided by the principles of natural justice. I am reading section 58 subsection 1, and subject to the other provision of this act or any rules, the tribunal shall have the power to regulate its own procedure and the place at which it shall be have. And principle of natural justice, the provisions like this section 58 subsection 2, section 58 subsection 3 and the other provision, if the rules has been framed in that regards, to that rule also will applicable. And the appellate tribunal also have regulate its proceeding if there is any loopholes or the lacking. For that also the this tribunal can make the the regulation. Okay, then in the section 58 subsection 2, because this is applicable for the adjudicating officer also, and it is applicable for the appellate tribunal also. The appellate tribunal shall have, for the purpose of discharging its function under this act, the same power as are vested in a civil court under the civil Code of Civil Procedure 908, while trying a suit in respect of the following matter: summoning and enforcing the attendance of any person and examining him on the oath, requiring the discovery and the prediction of the documents or the other electronic record, receiving evidence on affidavit, issuing commission for the examination of witness or document, reviving its decision, dismissing for the application in default or the ex parte. I think order 9 of the CPC about ex parte and other matters, etc. And then the subsection 3 is talking about the same manner that we read under the section 46 subsection 5 applicable for the adjudicating officer, just to stop the perjury and the execution of the order possible. So that you can read yourself, section 58 subsection 3. Then the next thing, or before that, there is another thing, like in the courts we have at the lower level only one judge as the presiding officer, but before the high court and the supreme court we have one judge, 3 judges, 5 judges, etc. So generally it is the odd number of judges, just to avoid the situation where there are even number of judges and both are of the different opinion, then which opinion will be prevail. Suppose there are 3 judges, 2 are in favor, 1 is against, so judgment will be in favor of suppose the accused. If 2 are against, 1 is in favor, so it would be considered as it is against. Okay. And so here is the section, one section, if the there is 2 presiding officer in the appellate tribunal, in that case how it has to be dealt with. And this thing, section 52 clause D, because this is also the part of the procedure. If the members of the bench, 52 clause D, decision by majority, if the members of the bench consisting of 2 members differ in opinion on any point, they shall state the point or the points on which they differ and make a reference to the chairperson or the appellate tribunal, who shall hear the point or the points. Suppose there is 1 point or more than 1 point, and such points shall be decided according to opinion of majority. All these 3 persons has to be, and either 2 or the 3, if goes in one direction, would be decided the fate of the case. Okay. So this is important. Along with, you can also read section 55, that order constituting appellate tribunal to be final and not to be invalidating its proceeding. So no order of the central government appointing a person of the chairman of the appellate tribunal shall be called in the question, and no act or the proceeding before the tribunal shall be called in question in any manner on ground of merely any defect. So if there is any defect in the constitution, etc., that technical thing, so that would not affect the validity of the order. Okay. Then the 9th thing is about that whether the decision of the appellate tribunal would be final, or is it possible to have the next appeal also. Because even at the appellate tribunal, if it is not compounding, then one party will win the case, another party will lose the case, and the party that will lose the case is known as the aggrieved party. So that aggrieved party is allowed to make appeal further or not. If we see in this regard to the civil procedure code, there in the civil procedure code, the 2 appeal are allowed, and so the first appeal, the second appeal, if you read section 100 of the civil procedure code, there the second appeal to the high court. So similarly here also, it was made possible that there would be the second appeal, and the second appeal would be to the high court, just to make that corollary with the civil procedure code. So yes, after the order of the appellate tribunal, aggrieved party may file the second appeal also before the high court. Then the 10th question and last question is about the time in which the appeal can be filed before the high court. For that we have this section, section 62, appeal to the high court, that any person aggrieved by the decision of or order of the appellate tribunal, any order suppose passed during the the appeal or to the final decision, if any party is the aggrieved, they may file the appeal to the high court, and within the 60 days from the date of the communication of the decision or order of the appellate tribunal to him on any question of fact or law. So it may be any question of the fact or law, it is not necessary the question of law only, etc. Okay. So second appeal is possible, and this has to be filed within the 60 days. Then again there is the question that if one is having some reason, maybe the ill health, or he was not sound, or he was got accident, and by that he was not able to file within the 60 days. So for that the proviso is saying, provided that the High Court may, if it satisfied that the appellant was prevented by the sufficient cause from filing the appeal within the said period, allow it to be filed by the further period not exceeding 60 days. So 60 days time period also be given if there is a sufficient cause, and that sufficient cause has to be satisfied. The High Court has to be satisfied with that. Okay, then there is one another thing, that suppose the penalty or suppose the compensation. So how that compensation has to be recovered? Suppose there is the two party A and B, and against A, who has actually unauthorizedly accessed the computer of B and deleted the data. For that he was for that B was awarded a damages, and A has to make the compensation. So A, if gives the money to the B, then it is good. Otherwise, how it has to be recovered? Section 64 talk that a penalty imposed or compensation awarded under this act, if not paid, if it is not paid, in that case shall be recovered as the area of the land revenue, and the license or the electronic signature certificate, as the case may be suspended. So this license or the electronic signature certificate is only with respect to the the controller. Okay, that controller order wala हमारे के लिए what is relevant, the compensation if not awarded, then it shall be recovered as the area of land revenue, so that revenue officer will recover this the compensation accordingly. So this is the procedure of the recovering of the revenue. So with these 10 question, with these 10 aspect, I have tried to finish this appellate tribunal, and even some portion of the appeal after the appellate tribunal also. And with this I have completed the procedure with respect to the appellate tribunal, where the aggrieved party can file the appeal after the order of the adjudicating officer, or if it is one is aggrieved by the order of the controller. So with this this is over.